Welcome to the third session of Child Protection 101. We're here today to talk about a subject that is extraordinarily relevant to all of you, and that is the appointment of the guardian ad litem, and then once a guardian ad litem is appointed, the duties, rights, and powers of that guardian ad litem. We're going to start first about talking about appointment of the guardian ad litem for children 12 years or younger, or for kids under 12. The statute in question is there, 1616-4. In any child protection proceeding for a child under 12, the court shall appoint a guardian ad litem and counsel for the guardian ad litem unless the guardian ad litem is always already represented. One way or another, a guardian ad litem is going to have an attorney. Either that attorney is pro bono or that attorney is appointed by the court. Ada County, many of the large jurisdictions have also all benefited as well from having very vibrant CASA programs that have been able to go out and recruit fine folks like all of you to serve as guardian ad litems. But again, there are some jurisdictions, particular smaller counties, that just don't have as many people and they don't have the ability to recruit as many volunteers as we've been able and fortunate enough to do here in Ada County, that they don't have guardian ad litems to appoint to children. And in that instance, if there is not a CASA program or there are insufficient numbers of guardian ad litems, then the court will bypass appointing a guardian ad litem and just go ahead and appoint an attorney. To recap, kids 11 and under, they're getting a guardian ad litem, they're getting an attorney to represent the guardian ad litem. If for some reason we don't have a pro bono attorney, the court appoints an attorney, and if we don't have a sufficient number of guardian ad litems, volunteers, then the court will appoint an attorney. One way or another, these kids are going to have a voice in their court proceedings. Now we're going to talk about required appointments for a child 12 years or older. When I did this presentation before, I said required guardian ad litem appointments, and I realized that that's not exactly accurate. So this is more accurate. For kids who are 12 years and older, the default is for the court to appoint an attorney to represent that child and need not ask or need not appoint a guardian ad litem as well. But there is no prohibition on a child 12 and older having both an attorney and a guardian ad litem. It is a resource issue, and historically in Ada County we have focused all of our volunteers to children 11 and younger. The bottom line is that for kids 12 and up, the default for the courts is to do an attorney. In certain unusual and unique circumstances, we also appoint a guardian ad litem for that child, and that guardian ad litem, one way or another, is going to have an attorney. And I suppose that if there is a county that doesn't have enough to assign an individual attorney to a child, but does have enough attorneys to have somebody represent guardian ad litems, you may have a situation of a youth being 14 with a guardian who's represented by a guardian ad litem attorney, but no direct representation of the child. So that is a possible outcome of this particular statute. Now, let's talk about appointing counsel for children. Nowhere in our statutes are there any definitions of the duties, rights, and powers of an attorney who is appointed as a counsel for a child. Also, in the Idaho Rules of Professional Responsibility, which are the guidelines for attorneys and how they do and conduct their practice, there is no specific statutory language that addresses this situation of what you do if you are appointed as an attorney to represent a 12-year-old or a 1-month-old. So we don't have any clear guidance from rule or statute exactly what the parameters of representation are if you are appointed for a child. There was a case in 2018, noted here in the interest of Jane Doe II, 164 Idaho 84, again from 2018, that was a guardianship case, and it states that in a guardianship case, one person cannot fill the dual role of being both a guardian ad litem for a child in a guardianship matter and also be their attorney. Prior to 2018, the form that the Supreme Court had for guardianship cases allowed judges to check both boxes when they were appointing somebody to assist a child in a guardianship case. And here locally, one of our judges checked both boxes, and the attorney who was appointed said, I am serving both the role as the attorney for the child and also the court-appointed guardian ad litem. That was appealed up to the Supreme Court, and they reviewed the statutes and said, no, that's improper. Can only be one or the other. So you're either acting as the child's express wishes attorney or you are their guardian ad litem, but you cannot be both. Guardianships and Child Protection Act cases are certainly different. We have different legal proceedings, different statutories, but I do think, and I will put on tape here, that I think it is safe to assume that the Idaho Supreme Court's logic would transfer over to a child protection case, that if you appoint an attorney for a child, they are not their guardian ad litem, and they do not have the duties, rights, and powers of a guardian ad litem. They are an attorney. Their job is to zealously advocate on behalf of their client and to share with the court what their client's express wishes are, meaning 14-year-old Johnny tells the attorney, I want to go home. That's my goal, that's my priority, and the attorney's job is to share that is what my client wants. Not to editorialize and say it's a horrible idea for Johnny to go home because mom is living under a bridge and dad's in prison and there's nowhere for this child actually to go. They don't get to weigh in. They simply express and advocate on behalf of the child what it is the child wants. And they don't, in my opinion, have all of the powers and responsibilities that we're going to talk about for the rest of the session that guardian ad litems do. The duties of a guardian ad litem are found and laid out in Idaho Code 16-1633. There are 5 of them, and the first is to conduct an independent factual investigation of the circumstances of the child. Stress, underline, put in bold, independent. You are not working for the Department of Health and Welfare. You do not work for the state. You don't even really work for the court. You're appointed by the court, but you're not my employee. You're not a judicial employee. You are an independent voice whose job is to go out and do a factual investigation and report back to the court what it is that you find. And I cannot stress how important it is that you do what you can to demonstrate and show that independence. It is a tremendous comfort to the parents in these cases. They're going to dislike you a lot of the time, but even despite their kind of inherent dislike of everybody involved who they believe with some understanding have taken their children away from them, I can't tell you the number of parents who ultimately come to truly appreciate the guardian ad litem and thank the guardian ad litem for being a voice that's not just in lockstep with the department and not just in lockstep with the prosecutor, but somebody who actually does the legwork, learns what's going on in these cases, and reports it as you see it, not looking to keep your job with the department, not to try and stay within the good graces of the prosecutor's office, doing what you need to do to independently come to a conclusion as to what's in the children's best interest. All right, the second duty of the guardian ad litem is to file reports for the following hearings: the adjudicatory hearing, the 6-month review, and the permanency hearing. At least 5 days prior to the hearing, and in those reports that are after the adjudicatory hearing, so the 6-month review and the permanency hearings, that you will, for any child capable of expressing their wishes regarding permanency, will include those express wishes in your report. You're all very familiar with the Ada County 4th District CASA form. There is a specific section that guides you to list what the children's express wishes are. Everybody that I can see is following that, and if the kid is of an age that they can tell you what they want to see for their future, you are including that, and that's how we conform and comply with this particular statutory requirement. I cannot stress enough to all of you how critical your reports, the department's reports, the parents' affidavits, if they strike them out, how all of that information is to the court in making their decisions. By design, judges are isolated from the world. I show up in the morning, I go into my chambers, I have a phone in my chambers. I get a phone call on that maybe once every 6 months. I'm not joking. Nobody calls me. I get a link to all of my hearings, which makes up the bulk of my emails. So I get a link for every hearing. So I usually get about 12 links every day for my hearings. And beyond that, I maybe get 3 or 4 emails a day. People don't email judges because you're not supposed to. Nobody should be communicating outside of the court with the judge. That would be what's called an ex parte communication. It's an attempt, maybe, to influence the judge to do something by also not sharing it with the other parties. And so the deal is that the judge is supposed to only receive information that everybody gets. And we do that in 2 ways. We get it through the reports and we get it from the in-court hearings. So I don't have a private investigator. I don't have the ability to pick up my phone and call the department and ask them how a case is going. I don't have the ability to learn anything about these cases. So I am making all of the decisions on every single one of these cases based on 2 things, and that is your reports, and those of the department and the parents if they do the right thing and also file reports, and what is told to me in the hearing. Beyond that, I get nothing. Guardian ad litem duties continued here. Number 3 is to act as an advocate for the child by participating fully in all child proceedings, because the word advocate has a very strong, specific meaning in the legal field of being essentially an attorney, like advocating, representing somebody. And I don't think that's entirely accurate in this context. We're not asking you to be an advocate for the child. We're not asking you to be an attorney for the child. Your role truly is to ensure that the children, what we're doing is all focused on what's in the best interest of the kids. You are going to participate fully in all the court proceedings. You're going to confer with the child, the siblings, the parents, and any other individual entity having information relevant to the child protection case. You are to monitor circumstances and ensure terms of court orders are being fulfilled and remain in the best interest of the child. I have yet to see somebody, a guardian ad litem particularly, come in to a court proceeding and say, "Judge, I'm here to ensure that the terms of your court orders are being fulfilled." Never seen it. Probably will never see it. It's not something that I think you receive any particular training on. Certainly monitor the circumstances and make sure that the case in general, that we are remaining focused on what's in the best interest of the child. Keep all information regarding the case confidential. Do not disclose the information except to the court and the other parties in the case. This is something that I am confident the CASA program in your training goes over ad nauseum and repeats over and over with you, and I hope that they are encouraging your attorneys to repeat over and over to you. This is about the one and only thing that will get you kicked off of a case. And I've seen it happen twice in my time, that we have had a guardian ad litem share confidential information to a non-party. I think in both cases it was former foster parents. So they had formed a relationship with a foster parent. The child was moved to a new home. The former foster parent wanted to continue getting an earful about how mom and dad were doing or how the kids were doing and stay involved as if they were still the foster parents. And the guardian ad litem, not maliciously, but because they wanted to be nice and they wanted to share information with this person that they had developed a relationship with, shared information, and it blew back on them. And it's been a long time ago, because it was Judge Hanson, of all people, who was the one who removed, and I'm sure many of you may not remember Judge Hanson ever being on the child protection bench. And so the best practice that I'd recommend here is for you to share the information you gather from all of the folks you're talking to, the counselors, the school teachers, the parents, the grandmas and the aunts and the uncles and everybody, the doctors, all of the folks you're talking to. You gather all that information up and you share it only in your written report and verbally at the court. That's the safe way to do it. Do not, as I say, it's a metaphor, you're a one-way street. You receive all this information, you write it all down, you share it with the court, and do not share any of your information with anyone else. Now, the statute does say that you can disclose this information to other parties to the case, and that's where it gets a little murky. The parent's attorney, I guess, called you up, and you and your attorney are comfortable having you talk to another attorney without them being present. I suppose you could share the information to the parent's attorney and to the parents, because they are definitely a party to the case. That makes me nervous, and I don't think that's best practice, and that's not how I would advise you. So basically, I would say just keep a hard, bright line. You gather the information, you write it in your report, you share it in court if you're asked by the court or any of the other parties. And outside of that, if people are pressing you for information, say, I don't wish to say anything. Really quickly, so I'll let you all get on with the rest of your day. Here are the rights and powers. We've talked about your duties. These are the things that the guardian has to do. Here's what you get to do as your rights and powers. This is in 16-1634. If represented by an attorney, the guardian may file pleadings, motions, memoranda, briefs on behalf of the motion and shall have all the rights of a party. There is the specific statutory designation of the guardian as being a party. We should just strike through that first clause, because you will be represented by an attorney one way or another in Idaho. So every guardian in Idaho is going to get an attorney. That's an archaic phrase that we ought to jettison. So everybody's going to have it. So you can trust as a guardian that you're going to have the rights and responsibilities of party. This is, as I say, a tremendous power. As we've already talked about, the department is not a party. Foster parents aren't a party. The kids aren't a party. And so the state, the parents, and the guardian are the only identified parties. You are the ones who actually have a right to petition the court for the court to do things. And so do not shy away from that power. Guardian has a right to prompt notification from all the parties to the child protection case about hearings, staffings, investigation, changes in circumstances regarding the child. Again, the department's not a party, but the state is, and so the state should be aware of all of the staffings and hearings and investigation, changes in circumstances. So by extension, the department needs to make you aware of anything that they're going to be doing. Now, clearly, there's all sorts of staffings and all sorts of incidental conversations that happen between social workers and their supervisors. You're not going to get informed about all of that. But if there is a group meeting that's happening about a child, if the child's in a congregate care situation and they're having a weekly staffing or monthly staffing, you as guardians absolutely need to be informed, and you have a right to participate if you are available to do so. Upon presentation of a copy of your order appointing guardian ad litem along with your photo identification so that the place that you're presenting this to is sure that you are indeed the person identified in the order, you have a right to inspect and copy all pertinent medical, school, Department of Health and Welfare, psychologists, psychiatrists, police, and mental health clinic records relating to the child and the child's parents, which just blows my mind, even without the consent of the child or parents. So this is where I say you all have a God order. This order issued by the court is incredible. It tells you that you alone can go to anybody you want to, medical, school, department, psychologists, psychiatrists, the police, hospitals. You can go in with your order and you can get access and copies of records for the children and their parents. And if any of you work in medical field, you're thinking, what about HIPAA? And guess what? This order cuts through HIPAA. You get access to these records. That's why you have an attorney, because you're going to encounter, no doubt, somebody somewhere saying, no, you don't actually get carte blanche to all of my records. I've never seen it. It's outrageous. It's not the way we do business. You're not getting access to mom or dad's counseling records from our organization. That's when you call up your attorney, and your attorney will call their attorney, and they'll sort it all out, because you do get access. There's no question. There are certain things you don't. Those are substance abuse records. Those are covered by separate federal law. Talk to your attorney about how you would get access to those kind of records. This is an extraordinarily powerful order. It is purposely so that you can get the information that we need to have in these cases, so you can make a recommendation as what's in the best interest. This has been a really fun hour. Thank you all for the questions. Obviously you've been asking questions all along. It's been a great discussion. I've really enjoyed it. And I'll let you go now.